state of the United States in this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have two cases on for hearing this morning. Before I begin, I want to welcome and thank our friend and colleague from the District of Maryland, Judge Paula Zinnes, who is joining us remotely this morning. Judge, thank you so much for being with us today. We know how busy you all are, as a matter of course, and even more so recently, and that you've taken time to be with us this morning says a lot about you and your colleagues. So thank you very much for joining us.
Thank you for having me. Looking forward to it.
First case up, 23-1752, Kelly versus City of Alexandria. Mr. Tucci.
Thank you, Your Honors. May it please the court. Robert Tucci, and I have the distinct honor and privilege of representing 10 current and former battalion chiefs of the City of Alexandria Fire Department, several of whom are in attendance for today's oral arguments. At a time of great fraught for public servants, I wish to thank them for their public service. Your Honors, this case presents an issue of first impression for this circuit. Specifically, what constitutes a salary guarantee within the meaning of Section 604B of the FLSA's implementing regulations for salary basis. The court below found that the city in this case paid my clients on a salary basis within the meaning of 604B, but not 602A. Now there's two alternative routes to reach salary basis. There's 602A and 604B. 602A requires that the weekly predetermined amount paid on a weekly or less frequent basis be fixed. It has to be fixed weekly or more frequently. Less frequently. The Supreme Court in Helix versus Hewitt found that what that means...
Mr. Tucci, before you get into the meat of your argument, I had just a general question about the nature of this pay scheme, which I think is, to say the least, a little bit complex and Sphinx-like in the way it's set up. And you just mentioned the two regulations that we're dealing with, 604B and 602A. Which one of those do you think applies in this case and why?
Your Honor, 604B applies in this case. And that's specifically because the Supreme Court has found that both 602A and 604B are not overlapping. In order to be paid on a salary basis, the employer must meet 602A or 604B. 602A requires that the salary be paid on a rate of pay or calculated using a weekly or less frequent rate of pay, meaning the unit of time. For 604...
Can I jump in for a second just to follow on Judge Diaz's point, which is the district court found as a matter of law that the battalion chiefs were paid on an hourly basis. Did they not? Did he not?
That's correct, Judge Zinnes. Judge Hilton did find that the battalion chiefs were hourly rate employees, and therefore they 604B applied.
B applied. And the defendants didn't cross appeal. So this court is limited, is it not, or one can make that argument, to whether the district court properly granted summary judgment on 604B. In other words, we're not to revisit what the district court found in the battalion chief's favor, that the defendants did not appeal. Am I getting that right?
I think that's correct, Judge Zinnes, and I think given the regulatory scheme of 602A and 604B, it's still important to discuss 602A because 602A defines what salary basis means. And because under 604B, the guarantee must be paid on a salary basis, 602A tells us what that means. And the Supreme Court has clarified what 602A is actually talking about. And that's where, of course, the salary or the guarantee must have a weekly or less frequent unit of time on the pay stubs, on the paychecks. Justice Kagan, in her opinion, actually wrestled with this. In oral arguments in Hewitt, she said it's a clunker of a sentence in 602A. And so, it's a really dense regulation, but at bottom, the employee must be paid using a weekly or less frequent rate. And here, the chiefs did not get a weekly or less frequent rate of pay. They got an hourly rate of pay. On their personnel action forms, it lists an annual salary. It also lists an hourly rate. Nowhere in their pay personnel action forms or the pay scales or any other documentation provided to them by the city does it list a guarantee paid on a salary basis. And so when we look at what other courts have done when confronted with 604B, the Sixth Circuit in Hughes, when looking at this language concerning a guarantee, said, okay, that makes sense. It's a guarantee. It has to be guaranteed. It has to be a matter of right, not a matter of grace.
Guaranteed in practice or guaranteed, because you seem to be making an argument that there was no formal agreement with respect to a guarantee, but your colleagues on the other side say that as a matter of practice over the years that is what in fact has happened, that there's always been a guaranteed number of hours and salary sufficient to warrant the battalion chiefs being considered to be exempt.
Thank you, Judge Diaz. And just to answer directly your question, it must be a guarantee in fact. And in this case, the city is pointing to...
Meaning what? In practice? Or what are we looking for in terms of the guarantee?
It must be a matter of right, not a matter of grace. And in Hughes, what the Sixth Circuit said was we look at the employment agreement and is it a contractual right for the employees. And so here, what the city has done is point to payroll records and then combined 10 separate pay codes to manufacture the illusion of a guarantee. There's nowhere within those payrolls, and that's at the Joint Appendix, page 87 to 198, there's nowhere within those pay codes that references a guarantee or that has any pay codes which are paid on a weekly or less frequent basis. And so the city also claims that this pay advance to the battalion chiefs that worked on an operational schedule, specifically where, given the natural cycle of the operations where it's a 28-day work period, there's 2 pay cycles within the 28-day work period. And for one of the pay cycles, it typically, a battalion chief or any other operational firefighter would work less hours than the next pay cycle. So to accommodate the firefighters, given this occurrence, they would essentially issue a pay advance for 106 hours minimum on the first pay cycle, and then on the second pay cycle, they would true up those pay advances and actually deduct from pay whatever amount of hours were not worked but paid in the previous pay cycle. So at bottom, it's a pay deduction, which is not allowed under the salary basis regulations. But it's not a guarantee, Your Honors, because again, there's no documentation. The chiefs were not even informed.
Let me ask about that deduction and true-up. But all of these things that were done, the deduction that you say, the taking from the leave account, which I also know you take objection to, were all in furtherance of assuring and ensuring that the battalion chiefs were paid a fairly consistent salary across the board, both for their operational work and their administrative work. And isn't that the intent of the statute and the regulations?
No, Your Honor. The intent of the statute and the regulations is to ensure that employees are paid time and a half for overtime worked unless they're a bona fide executive, administrator, et cetera. The statute provides the department, the Secretary of the Department of Labor, with the authority to define and delimit what the exemptions mean. And so that's where we get to 602A and 604B. The secretary has determined that to be a bona fide executive or administrator, you must be paid on a salary basis. And what the Supreme Court has clearly held is that means when you look at your pay stub, when you look at your payroll records, the rate of pay is not an hourly rate. It's a weekly or less frequent rate. And that's exactly what the case is here, Judge Diaz. The chiefs received an hourly rate, and in every work period, they were paid for their hours worked, or if they took leave, they were paid for their...
And they were always highly compensated employees.
Judge King, the highly compensated exemption is essentially a relaxed standard for the executive administrative exemptions in this case. And that was also at issue in Helix. The employee there earned over $200,000 a year, and he was paid a day rate. The employer in that case argued that his day rate, which at that time exceeded the salary level requirement by itself, that day rate, as long as he worked one day, he would be paid the day rate, and that therefore that met the salary basis requirement. The Supreme Court said that can't be the case because it's a day rate. Even if it exceeds the salary level requirement, the employee still must be paid a weekly or less frequent rate, meaning the calculations of the pay. And Justice Kagan notes that in her opinion. The pay must be calculated that way.
Well, let me ask you this. I know it's not your job to figure this out, but it's the employer's burden to make its case with respect to whether or not an employee is exempt or not. I think part of the problem here is the nature of the salary or the compensation structure is an attempt to reflect the very unusual responsibilities and requirements of time that these frankly very brave public employees take on. But that doesn't mean obviously that an employer can't pay these battalion chiefs a salary sufficient to make them exempt. So given the fact that we're dealing with these very strange structures, some firefighters are working operationally, some are working administratively, some are working 24-hour shifts, some are working 8-hour traditional shifts. What do you say that the employer, the city in this case, would have had to do in order to truly make these employees exempt?
Well, Judge Diaz, if the city wants to maintain an hourly rate and to calculate the chief's pay on an hourly basis, they can meet 604B's requirements by also providing them a guarantee salary paid on a salary basis per week. And that, of course, guarantee has to bear a reasonable relationship to the employee's actual earnings during the normal scheduled work week. That's straight out of 604B. And
counsel, in that regard, with what the city would have to do, if I'm getting the second prong of 604B right, you have to look at the actual wages paid by the city to the battalion chiefs and compare it to whatever that guarantee is. So if we just assume for a moment that there's evidence of a guarantee, and we're trying to figure out whether there's a reasonable relationship between the two, am I correct that we would look in the JA at the actual paychecks cut to the battalion chiefs, which show, kind of to illustrate Chief Judge Diaz's point, that this is very Sphinx-like. We've got a salary, and then we've got all of these additional pay lines for each check, which seem to make the point that there's no reasonable relationship between any base pay and what they're actually paid. I don't know if I'm making myself clear, but what I'm trying to figure out is, again, if we're keeping this really narrow to what the district court had decided, the district court's comparison were these hourly rates, and it doesn't, in my view, comport with the actual plain language of 604B, which says you have to look at the actual amount paid. And I wanted to make sure that you could address that in the context of Chief Judge Diaz's question about what could the city have done differently?
Thank you, Judge Dennis. And I think that's exactly right. I think when you look at 604B, there's no other way to read it. I think it says actual earnings, and then it goes on to say, what are actual earnings? Well, you look at the usual earnings at the employee's normal schedule work week. Here, the chiefs had a 28-day work period when they're on an operational shift, and then a 80-hour work period for an administrative shift. And so what would a guarantee look like in that situation? Well, it has to bear some reasonable relationship to what they're actually earning each work period. And so I think in that situation, the DOL has said a ratio of 1.5 is satisfactory. Anything over that, we'd have to look at pretty carefully. Here, I think it's pretty clear that there was no reasonable relationship. We cited the example of Chief Cook in the briefing, and his pay always had a ratio, when you look at the actual earnings, 1.7 to 1.8, roughly. And to remove, and I see my time is expiring.
No, you may answer, go ahead.
Thank you. And to remove the chief's overtime pay from that reasonable relationship analysis, it completely divorces the intent of the statute, of the regulations. The statute was designed to protect employees, and it's all about overtime work. It's all about what should you pay for the overtime hours. So I see my time is expired.
Well, no, that's okay. I actually have a follow-up question. So you just mentioned the ratio, which you think actually supports your point, but the district court, and it's always a bit problematic when judges do math of any kind, and so maybe you can help us with this.
I think lawyers in general.
And I'm excluding Judge Zinnes, who I'm sure is quite adept at math.
I'm sure about that.
But
So I became a lawyer.
Yeah.
And then a judge.
But tell me what was wrong with the math that that the district court in this case used in order to come up with a ratio that he seemed to believe satisfied the regulation in this case.
Well, Judge Diaz, it's really interesting what Judge Hilton and the city did to calculate their reasonable relationship ratio. What they did was they took the regular hour earnings of the chiefs and removed all other compensation that they earned during their work periods. So that includes overtime, and the city claims, a lot of that overtime is voluntary. And I think there's some dispute about that, but we don't think it matters whether it's voluntary overtime, involuntary overtime. All work is voluntary. No one can force you to work. And so I think in this situation, why are we removing that compensation? The regulation says what the employee actually earns, not what the employee's regular earnings are or non-overtime earnings are. And so that's what the district court did. Removed all of their overtime earnings to find that there's actually a ceiling for how much the reasonable relationship ratio can get to. Because essentially, take the administrative shift, for example. The district court found that only 80 hours of pay could be factored into the reasonable relationship analysis, not anything above that. It completely divorces the intent and meaning of the statute and the regulations. And I see my time has expired.
All right,
so thank you.
Thank you. You've got some time left for rebuttal.
Thank you, Your Honor.
Mr. Dabbs?
Good morning. May it please the court, my name is Dave Dabbs. I represent the city of Alexandria. The 10 plaintiffs in this case were paid on a salary basis because all of them regularly received predetermined amounts that were large enough to cover their normal work weeks, and it's undisputed that the city consciously and deliberately ensured that those amounts were paid without exception through the entire statutory limitations period. There were no improper deductions whatsoever. We think the court can affirm the district court's opinion as written for a couple of key reasons that I want to talk about. I would like to address
Mr.
briefly.
Dabbs, I'm sorry, before you get cranking.
Clock problem.
Sarah, is that timer working for Mr. Dabbs? or
This-
the other Sarah?
It was, yeah, it was running.
There we go.
Okay, sorry, it was running.
Very good.
Sorry.
Go ahead.
I did want to address, though, before I sort of talk about what I want to talk about even, that we do not think it was necessary for us to cross-appeal in this case because we are not asking for any different relief from what we asked for in the district court. Under those circumstances, as we understand the rule, the court can affirm for any ground supported by the record, even if the district court did not reach it or reject it. And that actually is a place that I want to go. But I'm going to start by telling you about the two key reasons that we think you can affirm as written. The first is that the city did provide a sufficient guarantee of the plaintiff's receipt of their predetermined amounts to qualify for exemption. And the second is that the city satisfied the reasonable relationship test. Now,
Can I ask the same question I asked of your colleague? That guarantee, is a guarantee in practice or a guarantee in writing or some other formal acknowledgement of the guarantee?
it is enormously clear under 602B that that is a guarantee in practice. Now, the regulation in 604B uses the term employment arrangement that includes a guarantee. We've cited the Coates case for the proposition that the guarantee in 604B simply means the receipt or the not being subject to reduction standard that's in 602A. And we think that's right for various reasons, and that's actually where I wanted to go in terms of a guarantee.
Mr. Dabbs, can I ask a question about how the city gets to the guarantee? If I understand it right, just because I think Chief Judge Diaz's point is well taken. This is very Sphinx-like, and I want to make sure I understand the details. It appears as if for every pay period, if there is a situation in which the battalion chief did not actually work the minimum hours expected to be paid, that guaranteed salary that you say?
Yes.
Then the city actually compensates at that salary, but it deducts annual leave to do it. So it's all calculated on an hourly basis where the city pays for the hours actually worked and then makes the difference up through annual leave. Am I getting that right?
It's not always annual leave, Your Honor, but it's always something. There is
Some other leave that is a code in the city's code book to make up the difference. Am I right?
Correct, yes. There are a variety of types of paid leave that are designed to do this. This is a point that Mr. Tucci has seemed to have difficulty grasping in some of his briefs.
I'm having difficulty too, so I want to stay with it for a minute.
Understood.
Answer the hypothetical for me. If there is, I understand that the city actually gives leave generously, but say you have a situation in which a chief runs out of all leave. There's no other leave available, and the chief, for whatever reason, does not work let's use an administrative chief because that's easy, 40 hours, does not work the 40 hours that week. How practically does the city make up the difference if there's no more leave left for that chief?
There's not really a practical answer to that question, Your Honor, because it has never happened within the memory of
Well, that's
of our guy.
different than what you would do. That's different than what you would do.
True.
What I'm hearing in that answer is, we don't know, but perhaps what happens is the chief doesn't get paid the guaranteed minimum because of the way in which it's structured. See, that's my concern, is that if you're relying on leave to fill the gap, then it's not a guarantee. It's just a practice of how to get there. And there is a theoretical possibility that if a chief doesn't have the leave, then the chief doesn't get the pay.
Your Honor, there is actually some deposition testimony on that from Mr. Bossi. And as I recall, and I'm not prepared to cite the page number, but it's in the joint appendix, his reaction was that if a situation came up where, you know, the payroll was showing that one of these employees did not have sufficient pay on the way, and that what he would do is check the rules, consult with the city attorney's office, that they would figure out whether or not the salary basis rules, the implication of this, figure out whether or not the salary basis rules applied to require payment. There are other exceptions to salary basis. I mean, if somebody is on certain kinds of disciplinary suspension, if somebody takes a full day for personal reasons, those are permissible deductions consistent with salary basis. Mr. Bossi showed an awareness of those rules. There's no reason to think that the city would not have responded appropriately to that. And the other point I would make, Your Honor, in response to that is that, you know, your question about was there a practical danger? That's the kind of question that the Supreme Court was answering in the Auer case, A-U-E-R, which is no longer well regarded under administrative law, but the substance of that is where the law was. And the changes that were made in 2004 actually moved the law further in the direction of simply looking for the practical answer of was the predetermined amount regularly received or always received. And it's very, very clear in all of the commentary that went with the regulatory changes in 2004, not only that deductions from paid leave are absolutely permissible, the money is just as green no matter how it's classified on the pay stub. We also think it's very clear from the language of 602 that there is no restriction on how the employer picks the predetermined amount.
Well, then how do you explain the true-up payments? The true-up payments seem to contradict that, at a minimum create a genuine issue of disputed fact, that the city has to, at the end of the pay period, the 28-day period, or at the end of the year, actually compensate the battalion chiefs to get them to the minimum, if I'm understanding it right. And in fact, according to the deponent that you just referenced, there were 5 years where the true-up payments weren't even made. So why doesn't that number one, and then we have at least one battalion chief who was paid less than the quote-unquote guaranteed salary, why don't those facts send this back for a more robust trial on whether there is a guarantee at all?
Your Honor, with all respect, I think you're conflating two things. One,
maybe, because this is really difficult.
Yeah, Your Honor, there has been some reference at some points in the case to what was called an annual true-up thing, which is a thing that was done at the end of the year. If anything, it shows that the city was particularly concerned about making sure that people got the full annual salary for every 52 weeks, that there was not even trivial deviation from it.
No, so the true-up is to make sure that you get the person gets the full salary.
Hold on. We don't rely on the annual true-ups. We rely on the payments every 2 or possibly 4 weeks for those periods. What Mr. Tucci is describing as a heinous deduction from pay is in fact just the simultaneous operation of 2 overlapping guarantees, one for 106 for every pay period. This is for the operational people. This has no application to the administrative chiefs. 106 is the amount of the guarantee for every 2-week pay period, and 216 is the operating minimum for any 28-day work cycle. That means that the various examples that play out, and we work through several of them in our brief.
Come out of some regulation.
Well, 216, actually not quite. They come out of the work schedule in some sense. The regulation for firefighters permits use of an overtime threshold of 53 hours. So for our non-exempt firefighters, for those extra 4, we always have to pay time and a half. And that's some of the tracking in the system reflects that history and the sort of configuration consistent with that system for non-exempts. So there is no deduction from pay. You could also view it, it's also.
Can I ask another question? Maybe this is much simpler. Isn't the pay scheme identical for all of the lower ranking officers, the captains and on down, but for the straight time overtime versus time and a half overtime? Just a real simple yes or no. Am I seeing that right?
Yes, you are seeing that right.
Okay.
We do not think.
Isn't that also a fact that could generate a genuine issue of disputed fact as to whether these folks, the battalion chiefs, are truly exempt employees or non-exempt employees? Just this fact that there really isn't anything different in the way that the city handles their pay, how they calculate the pay, other than the chiefs don't get time and a half on overtime.
Your Honor, there is absolutely nothing improper about paying a non-exempt employee on a salary basis.
Correct, if you do that. That's sort of why I'm asking, like, if in fact it's your burden and the plaintiffs are trying to generate evidence to undercut that burden, wouldn't one just very basic fact be that there's just no practical difference at all between the way in which the city calculates pay, deducts, uses annual leave or other leave to make up these differences, true up at the end? It's all the same but for one thing, which is that the battalion chiefs don't get time and a half for overtime.
Your Honor, all of the duties issues in this case were waived by the plaintiffs after we moved for summary judgment. There is absolutely no role in the salary basis analysis for how we paid some other group of employees. It simply has no role in it.
Why not?
Because it has to do with the pay to the employees that we are talking about. It's their pay system that matters. I mean, you can, I think, read the regulations in vain, and you will not see any reference to differences in how we pay other people.
So if I'm understanding that, you're suggesting that you could apply the same limitation on overtime paid to those captains and line officers?
No, Your Honor, we don't do that. We pay them.
I know you
time and a
don't
half.
do that, but could you do that?
Well, the pay system is consistent with doing that. Now, we have this court's decision in Morrison v. County Fairfax, which held on the exempt status of captains, and of course, it's not necessarily exactly the same. But we adhere to that. We treat the captains and all of the lower employees as non-exempt.
Okay.
Which poses no problem for this case. So let me proceed just a little bit. We think there are numerous reasons why the Hughes case is not a viable source of law for plaintiffs on the guarantee. One is historical. The Department of Labor specifically wrote the term employment contract out of the relevant regulations. When they revised them in 2004, they substituted the term employment arrangement, which clearly does not, we think, require a contract. The Department of Labor knows how to require mutuality when they want it. There's another regulation involving overtime calculation, 778.114, that requires a clear mutual understanding with employees. So the Department of Labor knows how to say that. Factually speaking, the statement that the plaintiffs rely on from Hughes is dicta. Hughes was a case where the employees, frankly, they had terrific evidence. The employer had told the people in writing that their quote-unquote salary would be $338 per day worked, which is direct evidence that the employer there was not paying on a salary basis. All the Hughes court said, really, was that the issue of the question of a contract, the existence of a contract, was not irrelevant. And that's correct in context. If the employer had had a contract where they promised salary basis with a merger clause, say, that would have destroyed the evidence that was the problem for them if it had supplanted it. Hughes also relied, I think, problematically on dictionary citations. And the thing we note is that what they found did not support their conclusion that contract was required. The key word was assurance. If you look that up in the same dictionaries, it just says something that gives or inspires confidence. We think there is confidence in this case because Mr. Bossi and his staff were fly-specking the payrolls. They were aware of the rules, and it was documented in a memorandum that Mr. Bossi drafted, which was circulated at a time when all of the plaintiffs were employed, which described, it was essentially an FAQ, which said, I only worked 96 hours this past period, how much do I get paid? And the answer was, you get 106, because you always get 106.
Mr. Debs, can I ask, assume for purposes of argument you meet the first prong of 604B, which is that there is a guarantee. How do you meet the second as a matter of law? Because the second prong reads that the promised amount must bear a reasonable relationship to the amount actually earned in a typical week. In other words, roughly equivalent to the employee's usual earnings at the assigned hourly, daily, or shift rate for the employee's normal scheduled work week. And maybe this is more specifically responsive to, the actual paychecks cut at JA 89 and forward. Why isn't that what we should be looking at to suss out the reasonable relationship test?
Well, Your Honor, you're prompting me along to my next topic. The discussion with Mr. Tucci, looking at 604B, focused on the first sentence of the regulation. We think it is critically important that the court should also note the second sentence of the regulation, which we think is actually the more technical and complete explanation of the rule. The second sentence reads, the reasonable relationship test will be met if the guarantee is roughly equivalent to the employee's usual earnings at the assigned hourly, daily, or shift rate for the employee's normal scheduled work week. Now, that phrase, normal scheduled work week, was critically important to the district court's opinion, because we do in this case have normal scheduled work weeks for both the administrative chiefs and for the operational chiefs. The operational chief's normal scheduled work week is their rotating 9-day cycle where they work days 1, 3, and 5. That's what's that is what generates the minimum of 216 hours for every 28-day work period. The district judge's opinion is completely proper, we think, in looking to that to establish what goes in the numerator of the reasonable relationship analysis. When that is done, the ratio, it's undisputed, I think, that if we are correct to use the normal scheduled work week, as the regulation specifically says, then that ratio comes in way, way, way below 1.5 over long periods of time.
But the example in 604B, the example is one that suggests you have to look at the actual rate and you compare apples to apples. So in the regulation itself, it uses the example of a shift worker who's paid actually, normally, he works 4 or 5 shifts each week, he's paid $350. That's the actual pay. Maybe you can make the argument it's averaged over time, but it's the actual pay as compared to the guarantee of $1,200. Here we have hourly workers. If you just stick in 604B for a second, And so isn't it fair to look at the actual hours worked over time, normalize them? But doing that means we have to go back to the actual paycheck and see how many hours each of the officers are working. Otherwise, are we not complying with 604B?
Well, Your Honor, I mean, our view of that, and there are a number of interesting uses of what I will call loose introductory language, but there is one sentence in that reg that is very, very specific. What goes on each side of the ratio? And the Department of Labor has been equally clear about what generates a reasonable relationship. One of the difficulties, I think, of the approach that Your Honor is suggesting is, I mean, one would have to do real-time monitoring on the employees, and there's absolutely no guidance that would tell us what we should be monitoring. If you're trying to figure out, for example, I think this is a good example, if an employer is covered under COBRA, it depends how many employees there are, but they tell you exactly in the law somewhere what you should be measuring. Is it at any date in this or the previous calendar year? They tell you what to look at. There's nothing here that does that. The only place you can find a consistent thing to compare to is to look at the normal scheduled work week, and then that tells you how much the guarantee needs to be.
And it doesn't matter how, in practice, that normal scheduled work week doesn't really align with the realities on the ground. So the employer says, in this case, 40 hours for administrative battalion fire chiefs, 3 24-hour shifts over the course of a week. But if in practice they work substantially more, I mean, who gets to decide what is normal is the question.
Well, I mean, it is a term to be interpreted. In this case, when an operational battalion chief is working outside of his normal 9-day rotation where he works days 1, 3, and 5. By definition, he is not working with his normal group of people who report to him. He's substituting somewhere else. He may be on the other side of the city. He may be doing completely different duties. And these shifts are scheduled in completely different ways. Our Assistant Chief Cross gave an affidavit, he did several, but it was one of the later ones, where he describes the system. You can compare, Mr. Bossie's affidavit has a calendar in it, which is, it's an annual calendar. It's done in the 3 colors, tells you when your shift is going to be on. You can look at that calendar now and know if your shift is scheduled to be on at Christmas. The extra shifts, overtime shifts, are done through what I kind of jokingly refer to as a dating site to match employees who would like to do extra shifts up with where they are available. That's not settled until 2 to 5 days before. And of course, that reflects the urgency that we need to provide public safety services for our citizens to make sure those things are carried. But they're scheduled in a wildly different way. And it is absolutely certain by definition that the chiefs are not doing their regular job. That plus the consistency of the rotating 9-day schedule, we think makes it very clear that that is the normal scheduled work week.
Mr. Dabbs, your time is up, but let me ask my colleagues if they have any other questions. Judge Zinnes?
Just have one, is that okay?
Sure, yeah. Have at it.
So, thank you. I just, in response to your point about normal doesn't mean actual work, didn't Justice Kagan in Helix clarify this to some degree when explaining that 541604B, that reasonable relationship has to be comparing, and let me find the quote for you because I really would like to hear from you on this. The promised amount must bear a, quote, reasonable relationship to the amount actually earned in a typical week. more specifically, it must be roughly equivalent to the employee's usual earnings, blah, blah, blah. Now, my question is, she's comparing the guarantee to the amount actually earned. How do we say, how does that tell us anything other than we have to look at the actual pay?
Your Honor,
Doesn't Helix emphasize that?
Helix was a 602A case.
Which went very specifically into 604B, because
Right,
I thought.
as a comparison, yes.
Since Mr. Hewitt was paid on a daily basis, right, per day, he was kicked out of 602A, so the analysis was under 604B. Did I get that wrong?
Your Honor, I think I always took it as assumed in that case that 604B could not be used. My understanding
may be right.
of the reference to amount actually earned, that was use of that language from the first sentence as a reference to the rule. There was no hint in Helix, certainly that I can recall, of anything that suggested that the court had any problem with the second sentence. And of course, the roughly equivalent language is further explained in the third sentence, including by the example. So when you get to the places where each of the elements in the test are explained, we think that indicates that Judge Hilton did it right, even though he made two contradictory holdings on 602A, which is the other point that I had wanted to get to.
All right, thank you, Mr. Dabb.
Thank you.
Thank you.
Mr. Tucci.
Thank you, Your Honor. Judge Dennis, just to follow up on your question concerning Hewitt, you're right in terms of the employee in that case. Justice Kagan and the court found that his pay scheme could not meet 602A, so he had to fall under 604B. That's why she discussed 604B. In that case, the parties essentially agreed that he could not meet 604B because of the reasonable relationship analysis. Now, returning also to a question, Judge Dennis, that you posed to my friend on the other side, in terms of this annual salary, what is that for the chiefs? Well, the city's claiming that they don't have just one salary, they have two. It's sort of like a salary inception. On their personnel action forms, of course, it lists an annual salary, and their hourly rates are derived from that hourly annual salary. The true-ups at that were given some years apply to the annual salary, not to the salary guarantees that the city is alleging that the chiefs have. But there is a true-up for the alleged guarantees as well. What happens is, for chiefs that work an operational schedule, if they're paid, let's say during the first pay cycle on the 28-day work cycle, the first pay cycle comes after 14 days. If they only work 96 hours, the city issues a pay advance. Really, it's a 0% interest loan. That's how you can think of it. They issue a pay advance for 10 hours to get to 106 hours. And then the following pay period, they deduct that 10 hours from their pay because they did not work it in the previous pay cycle. That is not consistent with being paid on a salary basis. It's consistent with being paid on an hourly basis because they're looking at how many hours they worked. Returning to this issue of...
So that would suggest a never-ending cycle. Do they then make up that deficit going forward for the 10 hours they took?
That's what the city's claiming, Your Honor.
Okay. Well, if they're making it up...
Where's the evidence of that, just in the JA, so we can see what this looks like?
So, Your Honor, if you, on page 91 of the joint appendix, this is for Chief Plunkett. If you look, there's a 12-hour regular time accrual that's deducted from his, and there's multiple instances of this throughout the pay records as well. But that negative 12 hours regular time, if you notice, is deducted.
Yeah,
from
I see it. Okay.
And so,
Thank you, sorry to interrupt.
no worries. And if, and actually, that brings up a good point, because if we look at what the administrative shifts were paid, the city claims that they issued a pay advance as well for these shifts. They call it a guarantee for 80 hours. That's nowhere in the record. The chiefs have directly controverted that in their declarations. The only source of that guarantee is in Matthew Bossi's affidavit for the city. So there's a genuine, at bottom, there's a genuine issue of material fact. But we believe that even if the court were to look at this and determine it was a guarantee, it's still not paid on a salary basis because they're using their hourly rates.
What do you want, go back for a trial? Some of it?
No, Your Honor, we actually moved for partial summary judgment. Actually, let me clarify. We moved for partial summary judgment on liability because we believe that the chiefs were not paid on a salary basis, and we think the record's very clear about that. There would, if the court were to enter summary judgment for the chiefs, we would then turn to the district court for a trial on damages.
But you're talking about what you want to have done. I'm asking what you want us to do.
That's correct, Your Honor. That's exactly what we would, what we're asking the court to do, is to reverse the district court, enter summary judgment for the chiefs, remand to the district court for trial on damages. Now, in terms of this questions and answers document that my friend on the other side mentioned, references this guarantee, nowhere within that document does it say the word guarantee. Nowhere within that document does it reference an administrative shift. It applies to firefighters working on an operational schedule. And it's the same 106 hours we just discussed in terms of one pay cycle, they're paid 106 hours. The following pay cycle, they true it up. They deduct the hours that they didn't work in the previous pay cycle. And then finally, Your Honors, oh, I see my time has expired. So thank you very much. And we would ask the court to reverse and enter summary judgment for the chiefs and remand to the district court for a trial on damages. Thank you.
Thank you very much. Want to thank both counsel for their fine arguments in this very simple case. We'll come down and greet you. I know Judge Zinnes would love to do that, but she can work
Virtual
well,
handshake.
she can work miracles, but she can't even do that. Can't do that. And then we'll take a break to discuss this case before moving on to our second case. Our second case is 24-1634 Houston Casualty Company versus Trident Construction Services, excuse me, LLC. Before we get started, I want to welcome and thank United States District Judge Thomas Johnson from the Southern District of West Virginia for being with us this morning. Thank you so much, Judge, for joining us.
Thank you. Happy to be. Good morning, Judge King.
Mr. Rannick?
Thank you, Your Honors. Good morning, and may it please the Court. This is a dispute about the scope of coverage under a CGL policy. There is not a dispute between the parties about whether there was an occurrence or whether there was property damage or therefore whether the policy itself was triggered. The question is, what is the extent of covered damage under this policy once it is triggered? And as to $295,000 of the claim, there should be no question about that either, and here's why. This is a case about water intrusion at a condominium building. HCC, the carrier, agreed to pay $91,000 for certain interior repairs following water intrusion from 3 severe weather events in Charleston, South Carolina. There was also defective construction that, combined with the weather events, caused the water intrusion, caused interior damage. Again, HCC agreed that the policy was triggered and paid $91,000 for certain interior damage. They also acknowledged that other portions may be covered to the extent they related to interior damage and asked Trident for further information. Trident gave that information, identified $295,000 that related to interior repairs, and never heard from HCC again about it. It was never rejected, rebutted, countered, never paid. And to this day, even after the lawsuit was filed and discovery was conducted, there is still nothing to rebut that $295,000 relates to interior damage, and thus, even under HCC's coverage interpretation, which, as we all know, differs from Trident's, should be covered.
How do you say that $295,000 relates to the interior damage?
So it was, they were costs incurred in performing the interior repair. So there were certain categories of costs that...
How are they different, I guess, from the 90+ thousand that was paid without objection?
The 91,000 were categories that were entirely relating to interior damage. The 295 was categories, some of which was interior, some of which was exterior. For example, dumpster rentals, permitting, certain aspects of the work that were necessary for the project as a whole. And so the question was, okay, dumpsters, sure, to the extent you're using those for interior damage, HCC says we should pay that. So Trident said, okay, let's tell you how much of each of these categories applied to interior versus exterior, and that's how they came to the $295,000.
Now, if I understand your colleague and on the other side, the response to that is we've got this blanket statement of charges related to the repair work, but nothing more. I mean, did you have to give anything more?
Thank you, Judge. I don't believe that we did, because if we did, I assume they would have asked us for more and we could have provided it. During the deposition of the claims adjuster, he said, we rely on the information that we get from our insured. The information they got from their insured was a pretty detailed breakdown of each of these categories and how much related to interior repair. Had they wanted more, they could have asked for it and they would have received it. But I don't believe anything more was required. It was the insurer's duty to investigate. And once we've brought the claim within coverage, I think if there's more information that they need, it's incumbent upon them to seek it. So what I would say is the primary issue today is the other $318,000 and whether that is covered under the policy. And the question is, of course, we have my friend and I have different interpretations of how coverage is determined here. Trident's position is once the policy is triggered, the insured has met its burden, and any element of the claim that is not covered will not be covered because of an exclusion, and it's the insurer's obligation to prove that an exclusion applies. Here, we say there is no applicable exclusion. Now, the one exclusion that was cited by HCC was exclusion M, and I'll confess I find this to be among the more impenetrable exclusions in a CGL policy, but its purpose...
Well, let me stop you there. Before we get to the exclusion, you sort of just made a blanket statement that once coverage is triggered, that's the end of the story. But that doesn't mean that each element of a claim necessarily is encompassed by the coverage scope of the policy. And as I understand, their principal argument is that the plain terms of the policy exclude the very claim that you are seeking to have, to receive compensation for.
I agree that is their version. We disagree. The case law in South Carolina distinguishes claims that are solely for property, for the defective construction, and claims.
Garfield agreed with that.
He did indeed, Your Honor. He did indeed, Your Honor. But South Carolina, if you look at the cases, if you look back to LJ versus Bituminous, if you look at Newman, if you look at Crossman, and the cases cited by Crossman, the way South Carolina courts conduct this analysis is there cover damage under this policy? That's the first question. And they distinguish between cases where the only damage alleged is defective construction and cases in which defective construction leads to property damage, interior resultant damage. And they find that when there is the latter, when there is both a defect and damage, the policy is triggered. And then it's the exclusions that apply to take defective construction out of coverage. And that's typically the your work exclusion, exclusion L or J6. Here, and this is why this case is different from any other case, this policy doesn't have those exclusions. They were removed by endorsement. And this is an issue of first impression. There is not a case construing a policy where these two exclusions were removed.
Well, how do you reconcile the Crossman decision that talks about the definition of property damage as excluding coverage for faulty or defective work?
Because the policy itself covers more than property damage. It covers damages because of property damage. And using the plain words, what does because of mean? Let me back up. There are many interpretations of what because of means. It can mean either the only cause of, it can mean a cause of. Here we would say the costs incurred to perform the exterior repairs were incurred in part as a result of the damage that occurred in the interior, as a result of the property damage, because absent that property damage, no one would have known that there were defects. There would have been no liability that Trident would have faced to perform those repairs. However, once they were discovered, Trident now would face liability to perform the interior repairs and to fix whatever caused it. Those are damages because of property damages that HCC's insured would face. Therefore, they're covered under the policy unless they're excluded. And here, there's no exclusion for defective construction. So that is how we conclude that the policy is triggered. First, it was triggered anyway, regardless of the costs to repair the defective construction. We see trigger as, and South Carolina cases treat trigger as a binary proposition. The policy is either triggered and there's coverage, or it is not and there is not. Once the policy is triggered, it becomes the insurer's responsibility to prove any applicable exclusion, to take the claim or any part of it outside of coverage. Now, to dive into the exclusion and exclusion M, the purpose of this exclusion is to remove coverage for the loss of use of another's work caused by a defect in your work. In contrast, the your work exclusion, L or J6, removes coverage for the defects in your work itself, including when one part of your work damages another. But, and I would note here that all of this project is Trident's work, because Trident was the general contractor and all of the work was performed on its behalf by subcontractors. So under the definition, the entire project is your work. But per the language of the policy, exclusion M doesn't apply for three reasons. First, exclusion M applies to property damage to impaired property or property that has not been physically injured. South Carolina law and Crossman, as Judge Diaz, you noted, makes clear that defective construction is itself not considered to be property damage. So exclusion M cannot apply to defective construction because that's not property damage to impaired property. It's not property damage under South Carolina law. With regard to the non-defective elements of the construction, it would apply only to the loss of use or reduced usefulness of these non-defective elements. And here, the non-defective elements, there was no loss of use. They remained in place until they were taken out and removed to the extent that they were during the repair process. And once it was taken out, then they had been physically injured, and exclusion M wouldn't apply anyway. Finally, there's an exception to exclusion M that removes those losses that arise out of a sudden and accidental damage to your work after it has been put to its intended use. Well, that is what we have here. We have storms after the building was complete and occupied. That was the occurrence that triggered the coverage here. It was after the building was put to its intended use, it caused damage, and all of the work that followed arose out of that occurrence. So exclusion M is not applicable. And in the absence of any applicable exclusion, there is coverage.
Doesn't your reading, though, of that language that includes after it's been put to its intended use, doesn't that negate the first subsection of exclusion M and make it superfluous?
I don't believe it makes it superfluous, Judge Johnston. I think it limits its applicability, but I don't believe that there couldn't be an instance where property damage to impaired property occurs during construction or before the building is occupied. So I don't believe it renders it superfluous, but perhaps I'm not understanding and answering your question properly. I'm happy to take any further questions that the court has.
This is not a question about the merits, but it struck me as odd that there's an allegation that the subcontractor in this project did defective work, and it appears the same subcontractor was hired to repair the work and was paid again? Does that make sense? That doesn't make sense to me, but, and you don't, if you don't need to answer that, I just thought that was strange.
It's a bit of an unusual circumstance, Judge.
All right. We'll leave it at that. Thank you.
Okay, thank you very much.
Mr. Haas?
Good morning, Your Honors. May it please the Court, Kevin Haas from Clyde & Co. on behalf of Houston Casualty Company. So this case is really not a complicated case. There have been a lot of decisions in South Carolina by the South Carolina Supreme Court that have addressed the various facts and circumstances as we see here. A situation where you have both faulty workmanship and you have resultant damage. The resultant damage can be covered, the faulty workmanship is not. So the background of this case, the facts are pretty much agreed. Trident was the general contractor for the construction project. Houston Casualty issued an OSIP policy that covered Trident and the enrolled subcontractors. This is all fairly standard. The policy was a CGL policy. The insuring agreement provides that HCC would pay sums the insured becomes legally obligated to pay as damages because of property damage caused by an occurrence. There were 3 weather events that caused water intrusion, damaging 4 units inside the condominium building. The owners of those 4 buildings demanded repairs. Trident agreed to repair the damage. But in addition, Trident decided that they would investigate the cause, figure out what was causing the water intrusion, and address it. So they turned to the 2 subcontractors who had done the exterior stucco and component work, and they asked those subcontractors to investigate and figure out what was causing the water intrusion. They did that. They confirmed that the water intrusion was being caused by faulty workmanship. The exterior stucco system and its components had been improperly installed. So the subcontractors repaired the interior units. They also repaired the exterior faulty workmanship. Houston Casualty paid Trident for the costs to repair the units, but Houston Casualty denied coverage for the costs related to the investigation of the cause of the damage, as well as the remediation of the faulty work itself.
Where do you say the $295,000 that your colleague began with falls in those three buckets that you just described?
Yes, Your Honor. So the 291 or so thousand includes the 91,000 that was paid, and it's a compilation of figures that are in an email from Mr. Burrell, an employee of Trident, where he explains his point of view as to what constitutes interior costs. Because what had happened was, as a shorthand, HCC paid for interior damage, which were the units, but didn't pay for exterior damage, which was the faulty workmanship. So using that dichotomy, Mr. Burrell asserted that certain additional costs above and beyond the 91,000 constituted interior damage work. But if you look closely at the Burrell email, among the things that he seeks to recover as interior damage are the waterproofing, which is the exterior damage. It's actually part of the stucco system that was damaged by the very same faulty workmanship. Copings, downspouts, and sheet metal, which he says had to be removed so the sheathing and waterproofing could be repaired. So these are the get-to costs as we classify them. Building envelope consultant, the cost of discovery should be reimbursable. So again, this is the effort to investigate from the exterior forward what was the cause of the water intrusion. So
So you're now explaining all of that here in court, and my next, I guess my question is, did you respond at all in that way to the email?
There was not a formal response to the email. There was discussion about the email, and in that discussion, the conversation went from where that email had been to a discussion about why they wanted to recover the entirety of their claim based on the because of property damage caused by an occurrence argument that my friend provided a moment ago. But what HCC did do is they investigated by hiring an expert, a consultant, a person who is knowledgeable about construction projects and circumstances where, because this happens fairly commonly, that the exterior system will have a construction defect and will cause leaking from water intrusion, and that will then cause additional damage to other people's property, unit holders, etc. So HCC, Houston Casualty, hired a consultant expert at that. That consultant evaluated the entirety of the claim, and that consultant concluded that the only part that was actually property damage caused by an occurrence was the damage to the units themselves.
Is that in the record?
Yes, Your Honor.
And did the district court grapple at all with that issue?
Not at all. In the case, both parties moved for summary judgment. There were cross motions for summary judgment. The court had before it the full record, which included deposition testimony, other exhibits and such. We submitted an expert report on that very same consulting issue. Trident decided not to submit an expert report. So on that record, Judge Gergel, who has quite a lot of experience dealing with insurance coverage issues, construction defect coverage issues under South Carolina law, concluded that this case was precisely within the construct of Crossman, LJ, and Newman, which are the three South Carolina Supreme Court cases that have addressed similar factual circumstances and have concluded that faulty workmanship is not property damage, faulty workmanship is not an occurrence, faulty workmanship is not covered, so therefore he agreed with our point of view that all you needed to provide coverage for was the damage to the interior units. You didn't have to provide coverage for the faulty workmanship itself, or the costs that you incurred to investigate the faulty workmanship, or the costs to get to the faulty workmanship, all of which do not constitute property damage and do not constitute an occurrance.
Is
under
it your view
established
that,
South Carolina law.
and I'm sorry to interrupt you, but is
Yes,
it
sir.
your view that the argument that's being made this morning, and I guess being made in the briefs, this attempting to slice the salami, for lack of a better sort of metaphor, is the 291,000, which you say includes the 90,000 that you concede was covered, was that argument presented, this argument that is now attempting to distinguish between, you know, things that are outside of coverage and things that are related to coverage, was that distinction presented to Judge Gergel?
I don't think it was. I think that I think that Trident below, just like here, put their eggs into arguments about, first, this because of argument, that all damages that are because of property damage caused by an occurrence are covered. It doesn't matter whether some of those damages actually were because of property damage and some of them were not. And I think also the argument about your work exclusion, how removing that somehow would negate the requirement to meet the insuring agreement, and the arguments about the impaired property exclusion, which were actually contrary to prior decisions by Judge Gergel. And I think that what happened is that he did not accept any of those arguments, and he concluded that they had not proved, which was their burden of proof, that the damages they were seeking to recover were damages because of property damage caused by an occurrence, which they were not.
How did the insurer respond to the email that sets out these additional claims that your colleague says are covered by the policy?
Well, I would say three different ways. One was there was a conversation among the lawyers about that email and about the claim and how there could be a potential resolution. And in the context of that conversation, the focus of that email was lost, and the discussion turned solely to Trident wanting coverage for their entire claim on this because of property damage caused by an occurrence argument, which Houston Casualty was never going to buy. In addition, Mr. Burrell was deposed in the underlying case, and when he was deposed, he was asked about what was the faulty workmanship damage, what was the unit damage, and he explained that the faulty workmanship was the entire stucco system, including the waterproofing. So there was an improper torquing of the screws that caused larger holes through all of it, and that then led to the water intrusion into the units. The third thing was, as I had mentioned earlier, Houston Casualty retained a consultant to investigate the loss in its entirety. Houston Casualty also submitted an expert report in the case concerning the same issue. So the Burrell email was addressed in 3 or 4 different ways before Judge Gergel at the district court level.
Well, I guess what I'm trying to get at is
Yes, sir.
the argument seems to be that, in the email anyway, that some portion of this work, which they admit had to do principally with repairing the faulty work, but some portion of the work also, for example, rental equipment, $20,086.59. They say, we request reimbursement for the pro rata share of the rental equipment not associated with the correction of the faulty work. And they say that reimbursement amounts to $5,124.13. So that's their claim, that, you know, 15,000 of it they concede, although they also believe that they're entitled to that. But at a minimum, they say 5,000 is associated with repairing. The stuck the units that were damaged. Why didn't that merit a response, or at least a resolution by the district court? All of these associated claims as they've described them.
Yes, Your Honor. As I had indicated previously, if you look carefully at that borough email, you can tell, you can discern that his use of the word interior damage is a very vague term, because he includes in his request for reimbursement as interior damage the waterproofing, which was part of the system that was damaged by the very same construction defect, the copings, the downspouts, and the sheet metal that they had to take off, and the subcontractors had to take off in order to get to the faulty workmanship, as well as the building envelope consultant on the assertion, and this is a quote, the cost of discovery should be reimbursable. So his concept of interior damage is actually not interior damage, it's actually exterior damage, it's actually construction defect, faulty workmanship damage, and then he uses that term to do the multipliers.
Well, that's a
that
great
Your Honor
argument.
has alluded to.
That's a great argument, but wasn't the district court required to resolve that? You say it wasn't. He says it was.
Well, I think that the district court did resolve that, because the district court had before it cross motions for summary judgment. And the district court had before it an expert report from Houston Casualty that described what constituted faulty workmanship damages, as well as the get to, the rip and tear to address the faulty workmanship damages. And he had nothing from the other side, notwithstanding that it was their burden of proof. So on cross motions for summary judgment, the district court can very clearly weigh the evidence and draw a conclusion that there isn't anything on the other side to try to prove what their burden is to prove.
So I also understood that your argument with respect to this 290,000 plus in damages is that they waived the argument. And how did they do that?
The point there is that below, in the trial court, they never drew that dichotomy.
They never described that to Judge Gergel?
They did not. They simply sought to recover the entirety of the loss on the because of property damage caused by an occurrence argument, followed up by the your work exclusion argument and the impaired property exclusion argument, all of which were rejected. So because the court was rejecting the argument that they made that they were entitled to everything, not just the $91,000 that had been paid, it was all rejected based on the same reasoning that the because of property damage caused by an occurrence argument is contrary to established South Carolina Supreme Court law. The your work exclusion argument is contrary to the construction of a policy, period. There's no basis in the law for that argument at all. And the impaired property exclusion argument ignored the policy language and ignored also prior decisions by Judge Gergel on the precise same issue and the precise same exclusion. And I think that's what occurred.
One of the prior decisions in the same case?
Not the same case.
So he could rely on a prior decision in another case? That's what you're saying?
Yes, Your Honor. Yes, Your Honor. So Judge Gergel held in the AMS versus Reynolds case.
It was precedent, you're saying?
Correct. Correct, sir. Correct.
I thought you were getting at a prior ruling in this case. You think it sounds like almost these cross motions for summary judgment were treated as a bench trial from my listening to your explanations here.
In a way, you know.
But there's a difference between a bench trial and a cross motions for summary judgment.
Yes, sir.
From a procedural standpoint.
Yes, sir. Yes, sir. No question. No question. But I think
And
that.
you're dealing with the cross motions for summary judgment, not a bench trial.
That is correct, Your Honor.
So Judge Girdle wasn't entitled to find disputed facts.
That's correct, but if there was no support for one party's facts and there was support for the other party's facts, there is no dispute. So I'll just quickly, so in terms of the impaired property exclusion, I just wanted to talk about that briefly. So our position is that there's no property damage, no occurrence arising from faulty workmanship, so therefore there's no coverage for the faulty workmanship itself, for the investigation of it, for the repair of it, and for the costs to get to it under the cases that I cited, L.J. Newman and Crossman, as well as the Lacey decision from the district court. But Judge Gergel also relied on the impaired property exclusion, and the impaired property exclusion, the point of that in this context is that if you have property that has not been damaged, but it must be damaged in order to repair certain property, that there is no coverage for that based on the impaired property exclusion. And that's exactly what Judge Gergel held. And he recognized that Trident was ignoring the disjunctive or in the main part of the policy, but he also recognized that they were misreading the sudden and accidental exception. So the sudden and accidental exception in the impaired property exclusion is saying that after your work's been put to use, if there's some sudden and accidental event that damages that work, the exclusion doesn't apply. That's a different situation. And for that, you need to have loss of use, which there is not here. There needs to be physical injury to other property, which there was not here, because Crossman says faulty work is not physical injury, it's not property damage, so there was not that. And also the damage to the units was progressive. There was no sudden and accidental event. It was progressive. There were multiple rain events that gave rise to the loss. Thank you, Your Honors.
Thank you, Mr. Haas. Do you have some rebuttal?
Thank you. Quickly, let me move through a couple of points. First, we disagree that the $295,000 included the original 91, and it's important for the court to understand the timeline of the sequence of events here. Yes, HCC hired an expert. The expert was hired and issued his report before HCC issued its reservation of rights, agreeing to pay $91,000 and declining the rest. It's only after that that Chris Burrell sent his email about the $295,000. That was never sent to the expert. There was no further investigation by HCC, and the record is clear about that. The next part, there were questions about the cross motions for summary judgment, and I would just note that our motion was a partial motion for partial summary judgment. We were only asking for a ruling on the overall coverage question. Now, HCC moved for complete summary judgment, including on our bad faith claim, and we opposed it, saying, well, there's this $295,000 outstanding. There's definitely a dispute of fact about whether their non-payment of that constitutes bad faith, and so we want to get trial on bad faith. And that argument was rejected because their motion was granted. The next part, it's important, and I didn't spend enough time on this, about trigger of coverage. And it is true that resultant damage constitutes property damage, and therefore can be an occurrence, and defective construction cannot. But this is a question of trigger. So Crossman, the issue that they have before them is we've got multiple years of coverage, and we need to determine when was the occurrence that will implicate these various policies. And they said the time that the defective construction occurred doesn't constitute an occurrence. You've got to wait until it causes damage. Once it causes damage, you have an occurrence. And and you have property damage, the policy is triggered. There is no case in South Carolina that requires there be a separate occurrence for each element of the damage that is part of the claim. There just is not. A careful reading of Crossman, a reading of Newman, of LJ, they all say once you have both defective construction and property damage, the policy is triggered. There is coverage. And then the question is the exclusions. And as I mentioned before, there is no case where these two exclusions were removed. So this is a new issue. And with regard to Judge Gergel's prior decision in 2016, again, the year work exclusion was part of that policy. Also, this precise issue, well, again, I haven't been able to find the policy in question in that case, but well, our position on exclusion M is based on a literal reading of the terms in the policy. And for the reasons that I articulated in our briefs, it does not apply to any of the categories of damage that Trident seeks coverage for. Another thing that HCC has never been able to satisfactorily explain is the effect or the purpose of removing the your work exclusion from the policy. We say, well, if there is an exclusion and it takes coverage away, then the removal of that exclusion gives coverage back. Now, in the 30B6 deposition of HCC, the explanation was given that the removal of this exclusion makes clear that resultant property damage is covered. But this exclusion has nothing to do with resultant property damage. And its presence doesn't exclude resultant property damage. And so that's not a viable explanation.
Do you have any authority for the proposition that the removal of an exclusion should play a role in the interpretation and reading of the policy?
Do I have express authority? No, Your Honor, outside of the myriad cases that talk about policies need to be interpreted based on their language and interpreted as a whole. And so when you have a specific endorsement that says we are taking this coverage or this exclusion away from the coverage, it has to mean something. All parts have to be given effect. And the only effect that can be given to the removal of an exclusion is giving that coverage back. And no satisfactory explanation has ever been given otherwise. Finally, I'd like to just discuss briefly the scope of the construction defect at issue here. My friend said that it involved the entire stucco system. We would disagree. It occurred during the installation of the stucco system, but as the lathe was being attached to the building for the stucco to then be attached to, the holes were drilled a little too big. Actually, there was not enough torque on the drills, and so the screws wallowed a little bit, which meant that their holes were slightly bigger than the screw through the water barrier. That allowed water behind the water barrier. That's the defect. So we disagree that it's the entire stucco system. It's just something that happened at the beginning, the outset of the installation of the stucco system. There's one last point I would like to make, and I'd like to draw the court's attention to footnote 4 of the Crossman opinion, which says, if an insurer wishes to exclude a certain category of damage, it is incumbent upon the insurer to do so in clear and plain language. I would argue that to the extent exclusion M is the basis for excluding defective construction, that obligation has not been satisfied. And with that, if the court has no further questions, I'm done. Appreciate your time.
Are you asserting that in this dichotomy of damage versus construction defect, that there was some damage on the outside to the stucco system caused by the defect in the screws?
No, Your Honor. We believe the stucco itself was not damaged.
Okay.
Thank you very much.
Thank you all.
We want to thank both counsel for their arguments this morning. We'll come down and greet you, both on behalf of the court and on behalf of Judge Johnson, who can't do that this morning. Judge, I want to thank you again for being with us. So we'll come, after we're done greeting counsel, we'll come back and conference the case. And with that, the court stands adjourned. Sani Da.
This honorable court stands